channel Rahul Prudent Study. In this video, we'll just covered about the next series of case material of law of crime. That is a cover due LLB first semester course code LB 104 course title Law of Crime 1. Previous video I just covered the first topic related to nature of crime and definition of crime, and in that video just covered few topics regarding the distinction and the relationship between the civil wrong, criminal wrong, ethics and moral wrong. Okay, and further I just going to cover the elements and constituents element of crime. Okay, let's before begin please subscribe this channel and press the bell icon to get notification on time. You can also join my telegram channel Rahul Prudent Study, and there is also a group namely Rahul Prudent Study. You can join, and I will also share this PDF in that group so you can easily access this PDF. While I am going to read, please open your case material to better understanding. Okay, thank you so much for being here. Let's I'm going to read. Please see your casement and the elements of a crime. Okay, the two elements of crime are mens rea and actus rea. There are two elements of crime are mens rea and actus rea. Mens rea means guilty mind, and the actus rea means actus reus, and act prohibited by law. Okay, apart from these two elements that go to make up a crime, there are two more indispensable elements, namely first a human being. There's a requirement of human being. Should be a human being for committing crime, of course. A human being under a legal obligation to act in a particular way and fit to subject for infliction of appropriate punishment. Okay, and secondly an injury to another human being by the first human being act. Injury caused death, harm, grievous hurt, etc. Human being and or to the society at large. Okay, thus the four elements that go constitute of a crime are as follows. First, a human being. There should be a human being under a legal obligation to act a particular way and fit to subject for implication appropriate punishment. Okay, secondly an evil or intent or mens rea, okay, on the part of such human being. Okay, thirdly actus rea, that is they committed or omitted in furtherance of such an intent. Okay, fourthly an injury to another human being or to society at large by such an act. Okay, these four elements are requirement of constituted crime. Okay, now I'm now just in brief understanding the a human being. Okay, the first element requirement that an act should have been done by a human being before it can constitute a crime punishable at law. The human being must be under a legal obligation to act and are capable of being punished. Okay, next the element mens rea, that is guilty mind. The second element, which is an important essential of a crime, is mens rea or guilty mind. In the entire field of criminal law, there is no important doctrine than that mens rea. The fundamental principle or doctrine of crime is mens rea. Principle of English criminal jurisprudence, to use maxim which has been familiar to lawyers following the common law for several centuries, is actus non facetium nisi mens rea. What does it mean? Mens rea. Mens rea is the state of mind indicating culpability which is required by statute as an element of a crime. It is commonly taken a mean some blameworthy mental condition whether constituted by intention or knowledge or otherwise, the absence of which on any particular occasion negatives the intention of a crime. The term mens rea has been given to violation, which is the motive force behind the criminal act. It is also one of the essential ingredients of criminal liability. Okay. Now, as a general rule, every crime requires a mental element, the nature of which will depend upon the definition of a particular crime in question. Even in crime of strict liability, some mental element is required. Expression edited from this. Okay. Expression. It's expression. Yeah. Expressions. Okay. Connotation of requirement of the requirement of mental elements include with intent, recklessly, unlawfully, maliciously, unlawfully, maliciously, willfully, knowingly, knowing or believing, fraudulently, dishonestly, corruptly, allowing, and permitting. Each of these expressions is capable of bearing a meaning which differ from the ascribed to any other. The meaning of each must be determined in context in which it appears, and the same expression may bear a different meaning in different context under the IPC. Guilt in respect of almost all the offence is fastened either on the ground of intention or knowledge or reason to believe. All the offences under the code are qualified by one or the other words, such as wrongful gain or wrongful loss, dishonestly, fraudulently, reason to believe, criminal knowledge or intention. Intention, cooperation, voluntarily, malignantly, wantonly. All these words describe the mental condition required at the time of commission of the offense. In order to constitute an offense, thus, though the word mens rea as such is nowhere found in the IPC, that is Indian Penal Code, its its essence is reflected in almost all the provision of the code. The existence of the mental elements or guilty mind or mens rea at the time of commission of the actus reus or the act alone with will be make the act an offense. Generally subject to both qualification and exception. A person is not criminally liable for a crime unless he intend to cause forces that he will probably cause or at the lowest forces that he may cause. The elements which constitute the crime in question. Although the views Although the view has been expressed that it is impossible to ascribe any particular meaning to the term mens rea, concepts such as those of intention, recklessness, and knowledge are commonly used as the basis of criminal liability and in some respect may be said to be fundamental to it. Intention. What does it mean? To intend is to have the mind a fixed purpose to reach a desired objective. It is used to denote the stand of mind of a man who not only foresees but also desires the possible consequences of his conduct. The idea perceives but also desires the possible consequences of his conduct. The idea of intention in law is not always expressed by the word intention intentionally or with intent to. It is expressed also by the words such as voluntarily, willfully, or deliberately, etc. Okay, Section 298 of Indian Penal Code makes the uttering of words or making gestures with deliberate intent to wound the religious feeling punishable under the Act. On a plain reading of the sanctions, the word deliberate and intent seem synonymous. An act is intentional if and in so far as it exists in idea before it exists in fact. The idea realizing itself in fact because of the desire by which it is accompanied. Intention does not mean ultimate aim and object, nor it is a synonym for motive. Okay. Now, transferred intention, that is malice. A case you can read the section 301 regarding the transfer of malice. Okay, where a person intend to commit a particular crime and bring about the elements which constitute that crime, he may be convicted notwithstanding that the crime takes effect in a manner which was intended or unforeseen. A intends to kill B. A intends to kill B by poisoning. Okay. A places a glass of milk with a poison on the table of B, knowing that at the time of going to bed, B takes a glass of milk. On the fateful night, instead of B, C enters the bedroom of B and takes the glass of milk and dies in the consequence. A wants to kill B, but B, in the consequence, C comes to enter the bedroom of B and takes the glass and drink the milk and dies in the consequence. A is liable for the killing of C under the principle of transfer intention or malice. You can see the bare act of IPC and section 301 regarding the transfer of malice. I'm going to read for you guys. Just give me 1 minute. Section 301 of Indian Penal Code says culpable homicide by causing death of person other than person whose death was intended. Okay, if a person by doing anything which is which he intends or knows to be likely to cause death commits culpable homicide by causing the death of any person whose death he neither intends or knows nor knows himself to be likely to cause. The culpable homicide committed by the offender is of the description of his he would uh, have been he is had caused the death of the person whose death he intended or knew himself to be likely to cause. They recommend accused is punishable for the murder under the doctrine of the transfer of malice. That is transfer of malice under the section 301 when he aimed at one person but killed another person. There is a case named Jagpal Singh versus State of Punjab of 1991. You can see this comment and case for better understanding. Now moving forward, guys, intention and motive. There is a word term intention and motive. What is this? And I just covered the transfer of malice, transfer of intention, transferred intention. So, intention and motive. Intention and motive are often confused as being one and the same. Okay, the two, however, are distinct, have to be distinguished. The mental element of a crime ordinarily involves no reference to motive. Motive is something. Motive is something which prompts a man to form an intention. Okay, intention has been defined as a fixed direction of mind to particular object or determination of an to act in the particular manner, and it is distinguishable from motive which incites or stimulate action. Sometimes motive plays an important role and become a compelling force to commit a crime, and therefore motive behind the crime become a relevant factor for knowing the intention of a crime, of a person. In Om Prakash versus State of Uttarakhand of 2003, Supreme SCC, and the State of Uttar Pradesh versus Arun Kumar Gupta, same year, the Supreme Court rejected the plea that the prosecution could not signify the motive for the crime, holding that the failure to prove motive is irrelevant in a case where the guilt of the accused is proved otherwise. Okay, it needs to emphasize that the motive is not an essential element of an offense, but motive helps us to know the intention of a person. Motive is relevant and important on the question of intention. So guys, the motive is not a element of a crime, but it helps to know the intention, the intensity of intention of a person. Okay, intention and knowledge. The term intention and knowledge, which denotes mens rea, appear in section 299 and 300 regarding the culpable homicide and murder. Having different consequences, intention and knowledge are used as alternate ingredients to the constitute the offense of culpable homicide. However, intention and knowledge are two different things. Intention is the desire to achieve a certain purpose, while knowledge is awareness on the part of a person concerned of the consequences of his act of omission or commission, including his state of mind. The demarcating line between the knowledge and intention is no doubt thin, but it is not difficult to perceive that they cannot different things. They may be knowledge of likely consequences without any intention to cause the consequences. For example, a mother jumps into a well. A mother jumps into a well along with her child in her arms to save herself and her child from the cruelty of her husband. The child dies, but mother survives. The act of the mother is culpable homicide. You can just read, guys, the element, the principles of culpable homicide. I'm just going to read. You can open your bare act, page number 106, 299, culpable homicide. Not 106, it's, yeah, 106. 106, just open. Yeah, I found it. Okay, culpable homicide, section 299 of Indian Penal Code regarding culpable homicide. Okay, chapter 16 of IPC. Okay, whoever causes death by doing an act with the intention of causing death. Okay, whoever causes death by doing an act, that is actus reus, with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, कुछ ऐसा कार्य करता है कि वो इंजूरी होगा, लेकिन वो इंजूरी का मौत का कारण बन सकता है। ओके, वो जानता है, और विथ द नॉलेज दैट ही इज लाइकली बाई सच एक्ट टू कॉज डेथ, और ये जानकारी है कि ये कारण जो मैं एक्ट करने जा रहा हूँ, ठीक है, या जा रही हूँ, वो मौत का कारण बन सकता है। कमिट्स द ऑफेंस ऑफ कल्पेबल होमिसाइड, ये ऑफेंस कैसा होता है? द ऑफेंस इज फॉर कमिटिंग द कल्पेबल होमिसाइड। देयर आर थ्री इलस्ट्रेशन फॉर culpable homicide. You can see the illustration number 1. A lays a stick and turf over a pit with the intention of thereby causing death, or with the intention, the knowledge that death is likely to be thereby caused. J, believing that the ground to be firm, treads on it, falls in and is killed. A has committed the offense to culpable homicide. Okay. Now the second illustration. A knows a knows Z to be the behind the bush. ये जानता है जेड कि जेड एक झाड़ी के पीछे छुपा हुआ है। बी डज नॉट नो, बी नहीं जानता है। ए इंटेंडिंग टू कॉज और नोइंग टू बी लाइकली टू कॉज जेड्स डेथ इंड्यूस्ड बी को इंड्यूस करता है टू फायर एट द बुश, की झाड़ी के ऊपर गोली फायरिंग करने के लिए। वी फायर्स एंड किल्स जेड, और भी फायर करता है और किल्स जेड को मार देता है, मर जाता है। हियर बी में बी गिल्टी ऑफ नो ऑफेंस, यहाँ पे बी नो ऑफेंस हो सकता है, गिल्टी ऑफ नो ऑफेंस होता है कोई, ठीक है, नॉट लाइबल हो सकता है। बट ए हैज कमिटेड द ऑफेंस ऑफ कल्पेबल होमिसाइड, बट यहाँ पे ऑफेंस कल्पेबल होमिसाइड के लिए देख सकते हैं, ठीक है। But you can also argue that this case would be the abatement, for abatement, because ये induced to be for the firing. So you can see this is the example of culpable homicide, but you can also apply the abatement case. एक केस के साथ बहुत सारे सेक्शंस लगते हैं, बट द मेजर एग्जांपल ऑफ culpable homicide. Okay. Next example, A by shooting at a fall with intent to kill and steal it. Okay, kills B who is behind a bush. A not knowing that he was there. Here, although A was doing an unlawful act, he was not guilty of a culpable homicide. He did not intend to kill B or to cause death by doing an act that he knew was likely to cause death. Okay. There are three examples relating to culpable homicide. First example, a person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. Second example, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Third example related to a murder child. Okay, the causing death of a child in mother's womb, मदर के गर्भ में कोई भी चाइल्ड का डेथ होना, not a culpable homicide. It could be a miscarriage case, but not culpable homicide. The causing of death of a child in the mother's womb is not homicide, because homicide is related to the livelihood. A living person could be a happened homicide. Okay, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been थर्ड फोर्थ कोई भी पार्ट ऑफ चाइल्ड बाहर निकला हुआ हो, though the child may not have breathed or been completely born. So, guys, this is the example or illustration regarding the culpable homicide. We can think you can think about the culpable homicide. What is culpable homicide? So here the mother done culpable homicide. Okay, she might not have intended to cause death of the child, but as a person having prudent mind, with law assumes every person to have, she ought to have known that jumping into the well along with the child was likely to cause the death of the child. She ought to have known as the prudent member of the society that her act was likely to cause death even when she may not have intended to cause the death of the child, so that the mother of the this case considered under the culpable homicide section 299 of the IPC. Okay, what does mean by the recklessness? Just intention cannot exist without foresight. ओके, इंटेंशन कैन नॉट एग्जिस्ट विदाउट फोरसाइट। अगर अज्यूम नहीं कर पाते हो कि इस इंटेंशन आपका क्या है, अज्यूम कर मतलब कोई इंटेंशन करता है कि हम उसको मारना है, तो आप तो फिर इसमें एज्यूम कर रहे हो ना कि उसको मार सकते हैं, तो इस फोरसाइट का मीनिंग हुआ बट फोरसाइट कैन एग्जिस्ट विदाउट इंटेंशन, बट फोरसाइट कैन एग्जिस्ट विदाउट इंटेंशन. For a man may foresee the possible or even probable consequences of his conduct, yet not desire this state of risk of bringing about the unwished result. This state of mind is known as the recklessness. This state of mind is known as recklessness. फिर से पढ़ता मैं. For a man may foresee the possible or even probable consequences of his conduct, and yet not desire to this state of risk of bringing about unwished result. This state of mind is known as the recklessness. Okay, recklessness. The words rash and rashness have also been used to indicate this same attitude. Okay, now negligence. Negligence, if anything is done without any adventure to the consequent event or result, the mental state in such situation signifies negligence. The event may be harmless or harmful. Of If harmful, the question arises whether there is legal liability for it. In civil law, common law, it is decided by considering whether or not a reasonable man in same circumstances would have realized the prospect of harm and would have stopped or changed his course so as to avoid it. If a reasonable man would not, then there is no liability and harm must lie where it falls. The word negligence, therefore, is used to denote blameworthy in advance inadvertence. It should be recognized that the common law there is no criminal liability for harm thus caused by inadvertence. Strictly speaking, negligence may not be a form of mercy. It is more in the nature of a legal fault. However, it is made punishable for the utilitarian purpose of hoping uh, to improve people's standard of behavior. Criminal liability for negligence is exceptional at common law. Manslaughter appears to be an only common law crime which may result from the negligence. Crimes of negligence may be created by a statute, and a statute may provide that it is a defense to charge brought under its provision for the accused to prove that he was not negligent. Sorry conversely, negligence with regard to some subsidiary element in the actus reus of a crime may deprive the accused of a statutory or defense which would otherwise have been available to him. Advertent negligence is commonly termed as willful negligence or recklessness. In other words, inadvertent negligence may be distinguished as simple. In the former, the harm done is foreseen as the possible or probable, but in it is not wild. In such latter, it is neither foreseen nor wild. In such case, carelessness, that is to say indifference as to the consequences, is present, but in the former this indifference does not, while in the latter it is does prevent these consequences from being foreseen. The physician who treats a patient improperly through ignorance for the or the furtherless forgetfulness is guilty of simple or inadvertent negligence. But if he does the same in order to save himself trouble or by way of a scientific experiment with full recognition of the danger so incurred, his negligence is lawful, willful. It may be important to state here that the willful wrongdoer is liable because he desires to do the harm. The negligent wrongdoer is liable because he does not sufficiently desire to avoid it. He who will excuse himself on the ground that he meant to avail it is still it is evil is still open to the reply. Perhaps you did not, but at all even you might have avoided it if you had sufficiently desired to do so. And you are held liable not because you desired the mischief, but because you were careless and indifferent whether it is insured or not. It is on this ground that negligence is treated as a form of mens rea, standing side by side with wrongful intention as a formal ground of responsibility. Now, the meaning of actus reus. To constitute a crime, the third element, that is actus reus, which we have called actus reus or which Russell has termed as physical event. Russell, a thinker, termed as physical event, is necessary. Okay. Now, what is this actus reus? It is a physical result of human conduct. When the criminal policy regards such a conduct as sufficiently harmful, it is prohibited, and the criminal policy provides a sanction or penalty for its commission. The actus reus may be defined in the words of Kenny, another thinker, Kenny, to be such result of human conduct as the law seeks to prevent. Such human conduct may consist of acts of commission as well as acts of omission. Section 32 of the Indian Penal Code tells about the commission and omission of act of our penal code lays down. The word which refer to the acts don't extend also to illegal omission. It is of course necessary that the act done or omitted to be done must be an act forbidden or commanded by some statute law, otherwise it may not constitute a crime. Suppose an executioner hangs a condemned prisoner with the intention of hanging him. Here, all the three elements obviously are present, yet he would not be committing a crime because he is acting in accordance with a law enjoining him to act. So, also, if a surgeon in the course of operation, which he knew to be dangerous with the best of his skill, and a care performs it and aid to death aid to aid the death of the patient is caused, he would not be guilty of committing a crime because he had no mens rea to commit it. As regards acts of commission omission which make a man criminally reasonable responsible, the rule is that no one would be held liable for the lawful consequences of his omission unless it is proved that he was under a legal obligation to act. In other words, some duty should have been imposed upon him by law, which he has omitted to discharge under the Penal Code. Section 43 lays down that the word illegal is applicable to the everything which is an offense or which is prohibited by law or which furnishes a ground for a civil action, and a person said to be legally bound to do whatever he is illegal in himself to omit. Therefore, an illegal omission would apply to omission of everything which he is legally bound to do. These indicate problems of actus reus we have discussed in details elsewhere. However, the two elements actus reus and mens rea are distinct elements of crime. They must always be distinguished and must be present in the order to crime may be constituted. The mental element of mens rea and or mental element or mens rea in the modern times means that a person's conduct must be voluntary. It must also be actuated by a guilty mind. While the actus reus denotes the physical result of the conduct, namely it should be a violation of some law, sanctuary, statutory, statutory, or the otherwise prohibiting or commanding the conduct. Now the fourth element, injury to human being. Okay, the fourth element, as we have pointed out above, is an injury to another human being or to the society at large. This injury to another human being should be illegally caused to any person in body, mind, reputation, property. Therefore, it becomes clear that the consequences of a harmful conduct may not only cause a bodily harm to another person, it may cause harm to his mind or his property or his reputation. Sometimes, by the harmful conduct, no injury is caused to another human being, as the act may be held liable as a crime because in such a case harm is caused to the society at large. All the public offense, especially offense against the state, example grace state, prison, sedition, etc., are the intentions of such harm. Okay, they are treated as the very grave offenses and punished very severely. Also, you may state again that there are four essential elements that go to constitute a crime. First, the wrongdoer who must be a human being and must have the capacity to commit a crime so that he may be fit to subject for infliction of an appropriate punishment. Secondly, there should be a evil intent or mens rea on the part of such human being. This is also known as the subjective element of crime. Okay. Thirdly, there should be an actus reus, that is an act committed or omitted in furtherance of such evil intent or mens rea. This may be called the objective element of a crime. Lastly, as a large result of the conduct of the human being acting with an evil mind, an injury should have been caused to another human being or to the society at large. Such an injury should have been caused to any other person in body, mind, reputation, property. If all these elements are present, generally we would say a crime has been constituted. However, in some cases, we find that a crime is constituted although there is no mens rea at all. These are known as the cases of strict liability. However, the cases you find that a crime constituted although there is no mens rea. These are also known as the cases of strict liability. Then again, in some cases, a crime is constituted although the actus reus has not consummated and no injury has resulted to any person. Such cases are known as the inchoate crime, where the actus is not present in the act. That act known as the inchoate crime. That crime known as the inchoate crime. Actus reus has not consummated and no injury has resulted to any person, known as the inchoate crime. Okay, like attempt, abatement, or conspiracy. Okay, so also a crime may be constituted where only for the first two elements are present. In other words, when there is intention alone, or even in some cases there may be an assembly alone of the person without any intention at all. These are exceptional cases of very serious crime, uh, which are taken notice of by the state in the larger interests of peace and tranquility of the society. So guys, this is for now. We just cover the uh, elements or constituent elements of crime. Next video will cover the case related to the first unit, state of Maharashtra versus Mayor Hans. You can see this is the good example of strict liability with the absence of mens rea or guilty mind or evil. Okay, so we'll cover in next video. Now for just for now guys, thank you so much for watching this video. I hope this video will help for the reading skill for the case material of law of crime. Thank you so much. Have a nice day and be safe. Thank you so much.